AM 1060 WMEL. The views expressed on the following program are those of the hosts, callers, and guests, and are not necessarily those of WMEL staff, management, or advertisers.
This is Joe Steckler, folks, your host for Helping Seniors, the radio arm of Helping Seniors of Brevard County. I'll deal with the commercial part of the show, and then I'll get with my panelist today. And my panelist is Bill Johnson, elder law attorney. But I want to first remind everybody that the purpose of the show is to inform, educate, and connect seniors and those that care for seniors to services they need to help them just live. And we're finding out more and more people are calling us back at the office. I talked to Kay before I came out to do the show today, and she said, Joe, we're getting more people repeating their calls to us after a year. You know, we helped them a year ago. They're calling back with new types of problems. And I just talked to somebody yesterday that's very prominent in working with all people in Brevard County, and he's involved now with the Children's Services Council, as am I. I'm one of the governor's appointees, believe it or not, folks, to the Children's Services Council, because I've always believed that seniors and juniors need to work together, and until we recognize that, we're not going to solve the problem. There simply is not enough money around to go around if we want to try and fight each other, and we should never do that. We should develop ways of figuring out how we can do better by marrying the senior and junior programs up so that we can take better care of everyone. It is possible, but it's not possible if you don't have people that are capable of working together to develop a plan. And having said that, I can look at all the battles that I've watched in this county since I came here in 1988 about funding, about who gets what, about what money goes to bring shares in of everything else. And you can prove a lot of right, you can prove a lot of wrong. But if you have a problem, call Kay at the office, 473-7770, and we'll do what we can to help you. Sponsors for the show include Kindred at Home, formerly Gentava, the largest home health skilled nursing care organization in the United States, the Eye Institute, Dr. Lee Sheldon, Bill Johnson, my panelist today, elder law attorney, Wusthof Hospital Systems, WMEL, Levin Home Care, Ebony News Today, and Atlantic Shores Rehabilitation, Riverview Senior Resort, and Organized Creative Designs. And don't be misled by that name, folks. That's the name of a ladies' company that helps seniors that want to downsize. And a lot of us are trying to make a decision whether or not we want to get rid of possessions. And that's the hardest thing for seniors to get rid of, possessions. Carla can help you make that decision. So think about calling her and just say, hey, I need to talk. And that's why I asked Bill today to go back and to do a show that we did years ago. I'm talking 7, 8 years ago. And it's called Basic Estate Planning. Bill, when I say a word like basic estate planning, how about just giving the folks an overview of what the heck I'm talking about and how an elder law attorney like you helps people make decisions? Because I had a lady call me last night and ask me about what you could do to help her. And I told her what she should do to make a phone call to go over and set up an appointment to talk to you. But I get calls like that all the time, and I like to refer people to somebody I know I can trust. So please tell our listeners, what's the answer to what I just said?
Well, the simple answer is who gets my stuff when I'm dead. And, I mean, it doesn't get more basic than that. Who inherits my assets upon my passing? And, you know, most people think, I'm going to do a will, and that's going to be the end-all, be-all to who gets my assets. And that's not necessarily true, because you can have beneficiary designations that may trump a will. You could have joint ownership of property that would pass by virtue of the joint ownership that would trump the will. And, of course, you could also have, something called a revocable living trust where your assets are in that. And then, the will wouldn't control what happens to those assets. So there are a lot of ways to pass your assets on to your heirs. But, most people think when we talk estate planning about a will and or a trust.
But a person that talked to me one day about her concerns were, Joe, I worked my whole life to put some assets in place to take care of me when I get older, and I would like to make sure that my children inherit some of the things that I've tried to work for. And the person was very concerned about learning about the cost of assisted living care and nursing home care, and thinking that she might have to go into assisted living care. And even though she's not a poor person, she's not what we call a millionaire. And how did she begin to realize that the cost of this nursing home and stuff we're talking $80,000-$90,000.
Well, that's a whole different issue than estate planning. Estate planning, you're planning on who's going to get your assets. In her situation, what we would be doing is long-term care planning. And she would have to come up with a way of protecting her assets. One way of doing that would, of course, be to buy long-term care insurance. She could simply insure against that risk. If she was that worried about it, insurance would be one way of doing that, especially with somebody who had substantial assets.
But how about, let's say, a person has $700,000 or $800,000, and are thinking 5, 6, 10 years into the future.
Mm-hmm.
What has the government done so that attorneys can legally develop niches to place assets in terms of home, wealth, money in the bank, stocks, bonds, possibly extensive collections of jewelry?
Well, there are ways you can go about qualifying to try and get benefits either as a veteran or getting benefits from Medicaid. There are techniques you could use to do that. But, if your primary goal, you have $800,000 and your primary goal is you want to stay home, you and me both know the waiting list for services at home from Medicaid is 58,000 people deep. So if you're worried that you may not be able to stay home, certainly the best way, if you had $800,000, excluding your house and your car, would be to buy insurance. Because if you activate your insurance, it's going to be there when you need it. Whereas if you're trying to apply for Medicaid through the home and community-based services, the long-term care managed care program for services at home, you're going to be on a waiting list.
Well, but before you even get to that waiting list, you have to spend that $800,000, or you have to have that $800,000 put someplace where it doesn't count as an asset for you.
Well, correct. Either, you have to get down below $2,000 in assets, excluding house and car and some other assets, but basically down below $2,000 before you're eligible for Medicaid. So you're going to have to, certain assets don't count. Like I said, house and car don't count. Believe it or not, rental property doesn't count for Medicaid purposes. So there are things that can be done to shelter assets, but that's still, even if you shelter all your assets and you get down below 2, you're still going to be on a waiting list if you're looking for services at home. So even if I made you Medicaid eligible tomorrow, you're not going to be able to get services at home. You're going to be put on a waiting list, and that waiting list is based on need, on how frail the person is, and you could be on that list anywhere from 6 months to 2 years. Whereas if you had long-term care insurance, you would just simply activate your policy.
And there are new types of products on the market now that will let somebody that does have a sizable amount of savings use part of that to pay for it on a monthly basis so they can protect themselves.
Well, there are products. There's annuity products where you put an X amount of dollars in an annuity, and that money's used first for your care, and then you can buy an optional rider, which is a lifetime care benefit. So you put like $150,000 in the annuity, and then once your health care costs, you use that $150,000, then anything above and beyond that is paid for by the annuity company. It's like having a very high deductible long-term care policy. And of course, if you don't use it and you died tomorrow, that annuity would pay out to your heirs.
And that's one of the advantages of having this new annuity-type product.
Correct. And it can also be done with life insurance as well.
Bill, in your practice now, and I know that since you've been an attorney and you've seen the law changes, you've made changes to your own practice. I know some of the people you have working for you. I know what some of them do. And I know in many instances the life of an elder law attorney has become maybe in some ways a little more diverse, but it's called for an elder law attorney to know a little bit more about the financial aspects of estate planning than maybe it was that they practiced years ago.
Well, I think if you're truly doing elder law, you pretty much know estate planning as well as, guardianship and incapacity planning, as well as long-term care planning. So you kind of are more well-rounded when it comes to things that could affect somebody's, estate as a whole.
So that's one of the reasons why when people are going through the directory of attorneys in Brevard County, you need to pay particular attention to what you put your finger on for the type of service that you need. And I think it's extremely important for people to understand more. That's why I wanted to do a basic show today. And just right along with that, I talked about being very careful about understanding a document you're reading and what you're saying. Now, I'm going to put myself, I told Bill about this before the show, folks, and I sort of put myself on the report because there were somewhere around 70,000 veterans in Brevard County. A lot of them get pay statements from, and retirees get pay statements from the Department of Defense. When I retired, I had 2 military-type policies that I was paying a monthly payment on, and at a certain age they became paid-up insurance. Well, I will admit that for some reason I just gave these documents to my tax consultant, and I didn't look at some of these documents to see what I was doing. And in fact, what I've done, folks, and I really put myself on report because I think some of you need to look at your own papers. In one instance, I've paid roughly $6,500 for a paid-up $5,000 policy that I'm paying $22 a month to maintain now. So I'm in a situation right now, at my age, I'd be very dumb to give up a $5,000 policy that's paid for, term insurance, that's in place, and it's only costing me $22 a month. So I want to keep it. But there are many other people that, because they don't look at documents, Bill, they get in situations like I've just described. Can you think of some of the things that people should be paying careful attention for so that they don't do what I have done?
Well, one of the things, we talk about on the show is, when it comes to your documents, every so often you go into your lawyer's office and have those documents reviewed to see if they're up to date and do what they're supposed to. Well, you should also be doing a financial review.
You're right.
Okay? You should be getting with your financial advisor and going through all your financial documents, and you should be meeting with your accountant and doing a tax review. So you may not have to do this year in, year out, but you should know, what's going on, not only legally, but, economically.
Well, that's the point, because here's the other part of that equation. I have a tax consultant that I talk to. There are, for every one that's in a situation like I'm in, there's probably 100 that just do it all by themselves. And they never go to a tax preparer. And how do they know?
Well, I mean, a good starting point for somebody, if they're trying to look for a very holistic view of all of this, is to go meet with a certified financial planner, somebody who has an understanding about how the estate planning works, how cash flow works, how insurance works, how securities work, how taxes work. That's what they're trained in, all those areas, so that they can advise somebody on all those different areas.
Let me ask you a question. Do you have a person like that that's on your staff?
No, I do not. I'm not a financial advisor.
So,
now, by the way, ladies and gentlemen, every person who works at a broker's office practically calls themselves a financial advisor. What I'm talking about is a certified financial planner.
How do you locate those people?
They have the designation CFP.
CSP?
CFP, Certified Financial Planner.
CFP?
Yep.
And they're listed in the phone book that way?
Yeah, they're listed.
How come in all the shows, the TV shows that you, Scott Glover, and the guy from the funeral home and I did about the three-legged stool on financial planning and how we plan for our ultimate demise, why didn't we ever talk about a certified financial planner?
Because you never asked, Joe. I don't know.
But the point is that no matter, Bill.
Well, let's back it up. A certified financial planner means somebody who has gone and sat for the certified financial planner exam, which looks at and tests the applicant's ability to do cash flow analysis, securities, anything to do with securities, anything to do with insurance, estate planning, taxes, and basically gives that person, it's like a 6-part test on all those different fields. And so that the person who, passes that has an understanding of how all the different areas interlock.
Yeah, and I think, and you and I have talked about this a lot of time. We're getting close to the break, but we're going to we'll pick up where we get stopped on the other side, folks. So just stay with us because we got some important stuff to talk about today. But when you're talking about the certified financial planner, I think it opens up a whole new ball game when you're talking about, because I guess what I'm saying. Too many people think you have to have $1 million before you need to talk to somebody like this.
Right. And the kind of certified financial planners you would go meet with, generally speaking, you want to go meet with fee-only financial planners, where they're going to charge you an hourly rate to deal with your problem. There are some who sell product, okay? So, they're going to, the idea behind working with the fee-only ones is they're not going to be biased on putting you into something that you may not need. So the fee people will just look at what your existing stuff is and then, can help you make recommendations on how that all interlocks.
So you recommend that they go to an hourly type person?
Yeah, a fee-only certified financial planner.
So they can tell you whether you have $100,000, $200,000, or $500,000, they might be able to offer you advice that will still save you money or let you do something so that whatever you do is more protected.
Right.
And that's one of the biggest things that's one of the reasons I wanted to go back and talk about basic estate planning, Bill, because too many people think that you have to be millionaires before you do estate planning. You don't, because you have family that want or may want some of your possessions that they would treasure, and if you don't do it right, if you don't handle probate right, if you don't, and that's something we'll talk about on the other side, because if you don't do these things right, they could lose all that, couldn't they?
Correct.
Okay, we're going to take a mid-show break, folks, and we'll be back on the other side.
AM 1060 WMEL.
This is Joe Steckler, folks. We're back live with the second half of today's edition of Helping Seniors. I remind everybody our job is to inform, educate, and connect seniors and those that care for seniors to resources to help themselves. Our phone number for Kay at the office is 473-7770. Our sponsors for the second half of the show include Senior Scene Magazine, Hometown News, Spotlight Magazine, Seniors Helping Seniors, The Fountains of Melbourne, Courtney and Braswell Financial Advisors, Barbara McIntyre, Home Equity Loan Specialist, Canadian Meds of Melbourne, Ear Care, who have 3 locations in Broward County now, Vitas Hospice, and Handy Pro of the Space Coast, and our newest sponsor, Al Dia Today, the Spanish-speaking newspaper. We'll have a monthly column in there, and we're starting to get more and more calls for assistance from the Spanish community, and I'll remind everybody that we do have a couple of ladies that are volunteering to help us that are fluent in Spanish. So if you call Kay and you need help with the language barrier, we have somebody we can connect you with so that we can find out what you're really trying to ask us. So there's no guesswork involved. We can get the job done. Today, my panelist is Bill Johnson, elder law attorney. We're talking about basic estate planning. And I got several things I want to whip through on the second part of the show. And, Bill, I'm just going to, what are some of the basic estate planning elements involved? What are some of the basic documents that people need to look at? Basic.
Okay, well, when you're talking about legal documents, your basic estate plan probably consists of a will, and then also having the incapacity documents like a durable power of attorney, designation of healthcare surrogate, a living will, and a pre-need guardian declaration. That makes up your basic estate planning. The will, is what your wishes are upon your death for your assets to transfer to your heirs, and who's going to be in charge of that process, what we call the executor, but in Florida we refer to that as the personal representative. And then the other documents deal with who manages your finances and your health care in the event that you become incapacitated and what your final wishes are. And then lastly, who would be your guardian if a guardianship was filed, which is where we go to court and have you legally declared incapacitated. Now, when we talk about estate planning, don't forget at the start of the show I talked about other ways besides a will that you could pass your estate on to your heirs, and that would be by a beneficiary designation, or if you had an account titled joint tenants with right of survivorship. A lot of people don't realize in Florida the presumption is that if you pass on and there's a surviving joint owner on your bank account, that bank account belongs to the survivor. So joint ownership can make a big difference as to who gets assets. And also, if you've created a revocable living trust and put assets inside that trust, that could determine, I have to look at the trust agreement and see who gets the assets. Wills go through a process known as probate. So a lot of people want to avoid probate. Well, how can you avoid probate? I just gave you 3 ways.
What is probate, Bill?
Probate is where you go to court and go through the court system to retitle assets into the names of heirs. You file the will, you get the will admitted, you get the personal representative appointed, we run the ad to the creditors, we pay the creditors, we marshal the assets, and then after the creditors are paid, we distribute the assets in accordance with the will. Since we go through the court system, that whole process is expensive. Somebody like me, an attorney, can charge 3% of the assets typically that go through probate. And there is a lengthy period of time that's involved, usually at least 9 months or so in the process. Now, you can avoid probate. You can avoid that fee and that time 3 different ways. One is, have everything jointly owned, because when you die, then it goes to the surviving joint owner. Or you could have a beneficiary on everything. So if you had all your estate consisted of was, a couple bank accounts and a life insurance policy, well, you could put beneficiaries on the bank accounts, make them payable on death to your beneficiaries, or you could fill out your beneficiary form for life insurance, and then all those assets would pass outside of probate. Or you could, create a revocable living trust and put your assets in there, and then when you die, your successor trustee would take over, marshal the assets, pay your debts, and distribute your assets. So 3 ways to avoid probate are by joint ownership, beneficiary designation, or a revocable living trust.
But what is...
If an asset isn't in any of those 3 categories, then that asset is going to go to probate, and that's where it passes by your will. If you don't have a will, there is something called an intestate statute, which is a statute who will determine who inherits that in the absence of a will.
So what you're saying, if you don't have a will, you could be in all kinds of trouble.
Well, your assets are going to pass per the intestate statute. And that statute does change. Since I've been practicing, it has changed. So it may not be what you think it is.
What do you mean by that?
It used to be if you died without a will and you were married, the estate, the assets that pass by probate would be subject to the intestate statute. And the old intestate statute said that if your spouse, if you had children and they were both yours and your spouse's children, and there were no children from anyone else, then your spouse would get the first $20,000, and then the estate would be split 50-50 between your spouse and the children. And if you had children that weren't both your and your spouse's,
okay,
then the estate would be split 50-50 between your spouse and the children without the $20,000. Then we bumped up the $20,000 to, I think it was $60,000. So the spouse got $60,000 and then split 50-50 if you had if the children were both of yours. And now we've done away with the whole thing. Now if you die and you're married, everything goes to your spouse. So that's just 3 different iterations of what happens based on changes in the statute. Also, if you're married, there are things called the homestead and elective share and family share. There are rights that spouses have in your estate that may affect the way your assets get distributed. You can't totally disenfranchise the spouse from the homestead house or all your accounts. They still have certain rights.
Bill, if a person doesn't do any estate planning at all, and they have a will, and they die, and things, what kind of messes can you get into?
If they don't understand how your assets pass, you can end up with all kinds of messes, especially in second marriages. That's where the big messes occur. Husband and wife get married, and they put all their money in joint accounts, but they never change their will. Okay? Husband dies.
I've seen that.
His will says everything goes to my kids. Well, I just told you, if you own a bank account jointly, one of you dies, the presumption is everything goes to the survivor. So that means, because they all had joint accounts, the wife got everything. So every so often I get all the kids who come to my office saying, the wife stole everything because Dad's will clearly says we get everything. And you have to explain to them, well, the will doesn't come into play when it's a joint account. And by virtue of it being joint accounts, everything went to the wife. I'm sorry. Nothing I can do to help you.
Is there a way to prevent all that?
Well, there's a way to, if you know how your assets pass, you can avoid setting things up where you have these areas of conflict. Now the joint account holder thing, for example, there are some exceptions to that. If you can show fraud, undue influence, or a contrary donative intent, you may be able to overcome that joint ownership presumption.
So,
but again, that's going to require litigation.
And that's all expensive.
Yes. So that may be as expensive or more expensive than probate.
Holy mackerel. What's the best way for the average person, average families, to not get into the messes that you and I are talking about today?
Well, one of the simplest ways is put beneficiaries on everything. If you have beneficiaries where you've gone down to the bank and you filled out a form saying, when I die, this is who gets this account, you're pretty certain when your kids show up with a death certificate, the bank's going to pay those monies out to those kids. And there's a form you filled out, you've signed, and it doesn't get any simpler than that. No probate involved. Don't have to go hire an attorney. Don't have to go wait 9 months to get your hands on the assets. So, simply by virtue of putting beneficiaries on most of your assets, you could avoid a lot of time and hassle. But you have to have kind of a comprehensive overview of that.
Yeah.
Because that may not be an option if you have, say, minor kids. I don't want to leave a $200,000 bank account to a 16-year-old. Probably not a good idea. So there are, times and places where, a trust may make more sense. If you have minor kids that spend everything they get, what we call spendthrift children, or if you have special needs children, it may make more sense to have some sort of trust arrangement.
Okay. Let's just say an average family, and here in Florida, or any place now, we get a lot of second marriages. And for whatever the reason was, you're in the second marriage, and you're very happy, and the two people love each other very much. Yet, does the law provide, or how do you protect your spouse in a second marriage if you've got what could be possessive children from a first marriage? How do you do that?
I don't know, Joe. You have a family meeting is what you do. You have to have some documents that really spell out who you want making your decisions. Is it going to be your spouse, your new spouse, or is it going to be your kids? Or is it going to be a combination of the two?
But my point is, if the people go to a guy like you that's seen all these situations, you understand a lot of the stuff that could happen, and there are ways, very simple ways, using a pen with a piece of paper and a signature, that you can prevent most of these messes from happening if you sign the paper right. You mentioned beneficiaries. You can have...
and a good, you need to do these things while you're competent.
Yes.
While your competency is not in question. When you're trying to do these at the 12th hour and you just had a stroke, and then you fill out all these documents naming your spouse, well, guess what? You're probably ripe for the kids to come and contest it all based on whether or not you had the capacity to do that. So you're just asking for trouble. So, a lot of this stuff has to be done well ahead of time.
Okay, and what we're talking about now, getting back to basic documents, you mentioned the durable power of attorney about 6 minutes ago. Having a durable power of attorney would come in tremendous play with the situation that we're talking about now.
Well, yeah, if you have given somebody power of attorney, that basically you've given the keys to your financial empire. They can go run around, sign your name, and do anything they want with those things. And, that is a great document if we need somebody to have that power to move assets around, pay bills, pay healthcare expenses. It's also a very horrible document if somebody has the intent to rob you. And if they're, intent on stealing your money, you just gave them the keys to the Ferrari.
And that's the point that I've been trying to make on the second part of the show with what you're saying, is that if a couple truly care for each other and they want to protect each other, whether it be the husband or the wife who has the assets, you need, as a husband and a wife, to go to an attorney and put the documents in place that will prevent children from any marriage doing what you don't want them to do.
True. And that's, you need to spell out what your wishes are, who you want as your decision makers, and what guidelines you want them to follow.
Yeah, but too many people believe that if I do a will, that's the end of the problem. And that's not the end of the problem.
No, because the will only covers you in the event of death. And a lot of what we've just been talking about is you haven't died. Right. You're incapacitated. You're still alive, but you can't manage your financial or health care affairs.
But that durable power of attorney, say somebody came to you and you prepare an estate plan for them, a durable power of attorney is a part of that estate plan.
Yes.
And it's roughly a 20-page document.
In Florida it is, because we have to specifically give somebody a power or they don't have it.
That's extremely important. That's what I was hoping.
Yeah, so if you moved here from like Illinois or New York or a couple other states where they have one-page power of attorneys, you need to get it redone because that's not going to be specific enough to do anything in Florida.
Yep. The point of it all is that when you come to Florida, you enter a different world. And you need to pay attention to what you're in.
We have a lot of statutes that say if your documents were valid in the state you were in when you executed them and then you move into Florida, we'll recognize those documents. The problem is we may not interpret them the same way. And so a lot of times that can lead to complications.
One of the questions I said, a general comment on how Florida law may differ from that in other states, especially the new changes. You've been talking about that, and I think it's something important that people need to understand, that if you're on Medicaid in New York or Medicaid in Illinois, the Medicaid changes when you come to Florida. We get so many more people coming to Florida thinking they're going to walk right into the top of a system to help them, and that's not true.
Well, Florida's better than most states, but yeah, each state interprets the Medicaid rules and comes up with their own rules for their own state agencies based on their interpretation of the federal laws. And then you have a whole system of what they call waiver programs, where the waiver program is where a state is asked for a waiver from the Center for Medicare and Medicaid to deviate and get creative, basically, with Medicaid monies. And certain states have programs, like Florida. We have a long-term care Medicaid waiver program that allows us to provide, for example, home and community-based services. So you can actually get Medicaid services at home or in an assisted living facility if you're over 65 and or disabled. You cross the state line into Georgia, that's not available. Right. The only thing they have available there is nursing home care.
Yep.
So everybody who needs Medicaid has to go into nursing home.
But conversely, Bill, one of the things that Kay and I have turned up since we've opened Helping Seniors, one of the biggest misunderstood areas are the benefits that veterans and their spouses are entitled to. I have spoken to so many retiree groups that invariably I always uncover one or two women that are unremarried spouses of World War II or Korean or Vietnam veterans that are eligible for VA aid and attendance. In some cases, that's $1,100, $1,200, $1,300, $1,400 plus medical benefits plus a whole lot of stuff that they simply don't know about because it's not published anyplace.
True, and we try to get the information out about that, but there is a VA program called Aid and Attendance that's eligible to veterans and the unremarried widower of veterans, and it's means tested, so it does have an income and asset test associated with it. So that is something that if somebody falls into one of those categories, needs to look into, especially if they need benefits for long-term care, because that's what that program's designed for.
And they have a veterans home over at Lake Mary and Orlando. There's just so much that has become available to veterans, and it's important that people understand the spouses of veterans. There are so many things that we can do to help people. And
now remember, all those rules are changing too.
They're going to change too. But I have to say that Dennis Van Orsdale, the veterans, one of the caseworkers out here at the local VA office, I think it's 632-2012, 632-2012 or 633-2012. It's one of the two folks. But they can sure answer your question. Bill, I want to thank you for everything you've told our people today. Sometimes it's good to get back to basics because we need to know what we need to know in a simple way sometimes to move on to advanced things. But thank you, Bill, for being here, and thank you, listeners, for listening. I'll be with you next week, and Dr. Sheldon will be my panelist, and we'll talk about teeth. He also talks about nutrition. See you next week. Bye-bye.